I am the Policy Director at the Asian Pacific Institute on Gender-Based Violence. Thank you for joining with us today. We are going to spend today, this webinar is specifically focused on Immigration 101. And so for those of you who don't or are experienced in working with survivors in the immigration law system, this may be a review for you because we're going to spend a lot of time talking just about how people get immigration status in the United States, and then we're going to spend a little bit of time specifically talking about protections for victims of domestic violence and sexual assault and other crimes. And then I'm going to talk a little bit about removal and deportation and what that is looking like in the current atmosphere. And then I'm going to talk about what people's rights are in the context of dealing with ICE and immigration enforcement. And so for those of you who are interested in more of the safety planning aspects of the work, we will continue that conversation tomorrow afternoon at 1 o'clock. And so you hopefully should have an email from the Institute on how to sign up for that webinar tomorrow afternoon if need be. But today's focus is going to be just on the basics of immigration law and how people can get status. So with that, the agenda is here, and I'll go ahead and get started. So first of all, I want to give you a larger framework of how the system works, and I generally do this because the protections that are available for immigrant victims, fall into this larger context, and folks are often really interested in just the protections for victims and forget that the folks they're working with may actually have other protections. And so I always do this larger overview. And I also start with just some basic terms because I'm going to start using a lot of jargon and acronyms, and I want to make sure that everybody's on the same page when I use them. And so this first particular slide talks about some general definitions. The first one being U.S. citizens, and those are individuals that are born in the United States or they've become naturalized after having had legal status for a while and they apply to become a United States citizen, or it's acquired or derived, meaning that they were able to obtain citizenship through a parent even though they were born outside of the country. And U.S. citizens cannot be deported. They generally can vote unless that right's been taken away. And it's the important factor to know because there are U.S. citizens that don't necessarily recognize that they are U.S. citizens because they might have been born in another country. But because they are U.S. citizens, they can't be deported. The next category is non-citizens. And I use this term non-citizens because there are folks that get confused about whether or not, what the term non-immigrant versus an immigrant is. And so I refer to non-citizens, and I do want to preface for you that the immigration law itself, which is found at 8 U.S. Code, the whole chapter is about non-citizens. The term that's used in the law is alien, and I generally choose not to use that word because folks are, there are other connotations to that word, and so the word I use when talking about folks that don't have U.S. citizenship are non-citizens. So the law allows, there are three general categories of non-citizens in the United States. The first one, when we talk about the concept of people being able to get status here, we generally are talking about folks that want to come live here indefinitely, and those that the law allows to live here indefinitely are lawful permanent residents, or LPRs. And so I'll be talking about LPRs as we go through, but they are folks that have green cards, and they are able to work here indefinitely. There's no restrictions on their employment except for the Office of the President of the United States. But generally, people, they can travel in and out of the country, and they are not generally able to vote, but they can live here as long as they want. And so the law, when people are talking about applying for status long-term, that's usually what they're talking about. The law also provides that there are categories of people that are protected under certain international treaties who are allowed to live here indefinitely, and those are asylees, refugees, and those withholding of removal. And generally those folks are allowed to live here indefinitely, and under our law can become lawful permanent residents. But those granted protection under those international treaties are also permitted to live in the U.S. indefinitely. Then we have some temporary non-citizen categories, the first one being non-immigrants, and those are categories of folks that have been admitted to the United States for a definite period of time, like a time-limited period of time, for a specific purpose, and those may include, students, temporary workers, visitors, or tourists, U visa holders, which are crime victim visa holders, and others. And usually the terms of the visa will determine what that person is allowed to do here and for how long. And if people don't comply with the terms of the visa, that makes them removable, or they are undocumented or should be considered undocumented. Their status can be taken away. So that is another category of people that are recognized in our law to be allowed into the United States for a period of time. Then there are other groups of folks who don't have a status that's recognized under the law per se, but there's been an executive decision or administrative decision by the federal government to allow groups or classes of people. Usually they're not large groups of people that have some kind of temporary status that the administration can decide, oh, we're going to end that today or next week. And so examples of that might be temporary protected status. Generally, that's a group of people that are afforded some time to stay in the United States because there's some kind of natural disaster or civil war or widespread communicable disease or something happening in their home country where the administration makes the decision to say it would be okay for these folks to stay here for a certain period rather than sending them home in a country that's destabilized for whatever reason. And so right now we in the news there's lots of media coverage about folks from Haiti, for example, and some various West African countries about whether temporary protected status is going to be extended for them or not. And so I think the current news, at least about Haiti, is that they've extended temporary protected status following some large earthquake and hurricanes, et cetera. in the last few years, and they've extended that till spring of next year, and so we'll see how long, whether or not the administration chooses to extend that again. There are also other groups of folks that are paroled into the United States because they're not eligible for a particular type of visa. For example, there are categories of people that, for example, the administration might let in when the refugee numbers for a certain year are, that are all taken up, or other categories of folks that, the administration might decide to let in for healthcare reasons or other humanitarian reasons. But that is also another administrative decision that the executive branch may decide. And then there's this concept of deferred action, and that is one where the executive branch, the DHS or the president decides that there's a category of folks that are in the country without authorization. They are removable or they're undocumented, but we know that they're here, and we've decided as a group of people that they're not a priority to deport, and so we're going to grant them this temporary status that says they're just not a priority for deportation. And so in the news right now, we've heard about the DACA program, otherwise known as Deferred Action for Childhood Arrivals, and that is several 100,000 people that have this status. In the context of the Violence Against Women Act, or in the context of U visa applicants, we have many people that have deferred action who are waiting for their cases to be finalized, and so there are just groups that have been granted deferred action where the administration decides, they're here, they're undocumented, but we're not going to choose to initiate deportation proceedings. And that category of deferred action is completely an administrative grant of kind of like a temporary pardon. It's not really a defense to deportation, and folks are not under the law entitled to stay, but for the grace of the administration at this particular moment or that particular time. So we've got large categories of people in that category right now that are getting a lot of news coverage. And then we have a large category, I believe, of almost 11 million people right now who are undocumented in the United States, and those folks are folks who might have overstayed or violated the terms of a visa that they had, or they might have entered without permission or inspection, from a customs or border patrol station, and they are very diverse. We know, for those of you in our API programs, that Asian Pacific Islanders are one of the largest growing groups of undocumented folks, but are not typically viewed in our media as those who are undocumented. But we all know in our programs and in our communities that we have many, many folks who are. And I want to frame for you, I use the term undocumented immigrant, and that is the term that, the language that's used in the style sheets for various major media publications. And we use that term because, first of all, it's a temporary, state. I mean, many people may be eligible for immigration status, and so the term out there about people being illegal or not illegal, when it describes a static characteristic, is not particularly appropriate, given that folks are often eligible for, or may be eligible for something, and just the philosophical notion that people are not illegal. And so we use the term undocumented immigrants or undocumented individuals as we engage in these discussions. So the next slide talks about which agencies are responsible for implementing immigration law. I don't know why I'm getting an echo. Okay. These are the various federal agencies that are responsible for carrying out what immigration law says. The first one, the big one, is the Department of Homeland Security, or DHS. And it's the umbrella agency that was created in 2003 that holds the various functions of immigration, implementing the immigration law. And so the first division is USCIS, and that is the part of DHS that does the services. It's the benefit granting part of DHS. And so they take applications for people to get status. They decide whether or not people, merit or are eligible for status and can grant people status or deny people status. And they also decide on applications for naturalization to become U.S. citizens. The next agency or sub-agency of DHS is Immigration and Customs Enforcement, otherwise known as ICE. And they're responsible for, they're kind of like the police function of the agency. Like USCIS is the benefits part. Immigration and Customs Enforcement is the police department in the interior of the United States. And so they determine whether or not somebody's violated the terms of their status or here without authorization, and they're the ones responsible for deportation of individuals. And so that's often the agency that we are talking about when we're talking about people being afraid of immigration. And then there's Customs and Border Protection, and generally you can think of them as like the exterior guard of the DHS. They have authority to work within 100 miles of the border, entire border of the United States, along the coast and on the northern and southern border. And they're in our ports of entry, whether in the airport and or at the physical border. And so they are, essentially the guard. And so if they detain folks that are not within the, that for somebody that's perhaps lived in the interior of the United States and has been in the U.S. for over 2 years, if they happen to catch somebody in that 100-mile radius, they would actually turn the person back over to ICE for enforcement action against them. And so generally, if somebody's been in the U.S. Continuously for over 2 years, ICE would have authority over removing them. If the person has been, in the U.S. Entered for less than 2 years, CBP has the authority to remove them much more quickly. And I'll talk about that more as we go along. The next federal agency is the Department of Justice. And as many of you know, there are many branches of the Department of Justice, but the Immigration Court and the Board of Immigration Appeals, those are both parts of what's known as the Executive Office of Immigration Review, so EOIR, and I didn't put that acronym in here, but the Immigration Court is the division that makes the decisions when ICE brings a deportation case, and there's usually a judge that decides whether or not that person deserves to, is eligible and deserves to not be deported, and then depending on what they decide, then the Board of Immigration Appeals is the agency that reviews those decisions. And so if there are appeals that are taken up higher than the Board of Immigration Appeals, sometimes it's taken up to the Court of Appeals, then the Department of Justice is responsible for defending or representing the government's decisions in those cases. And so sometimes when immigration cases are appealed, then it becomes the Office of Immigration Litigation, which is within the Department of Justice as well, that will represent the decisions of the Board of Immigration Appeals or the lower immigration courts. So there's DOJ, and then the next agency is that makes decisions outside the country. There are consulates around the world, and so we have our embassies in various countries, and they will process and interview individuals to decide whether they should be given a visa. So, for example, USCIS would take the initial application, make a decision as to whether the person is eligible and approve it or not, and then they send the application to the consulates, and the consulates will interview the individuals to figure out whether or not there might be some ground of to prevent the person from getting a visa to come into the United States. And so and that's in the context of non-citizens being outside the United States coming in. So I just wanted to highlight on this slide, it says INS is no longer with us. Some people still use that term, the Immigration Naturalization Service. That used to be the entity before September 11th of 2001, or actually it existed until 2003 when DHS was created. But INS used to hold all of the functions of USCIS and ICE together, and the Border Patrol, not so much the Customs. And so that no longer exists, and it was replaced by the Department of Homeland Security, and DHS, of course, has other functions within it, such as emergency management and other things, but INS doesn't exist anymore. So I wanted to just, this is for yourselves to figure out how much you know or don't know generally about immigration law. So I just want you to, think for ask yourselves these questions, whether they're true or false. And what I'll go do is, ask yourself to say true or false. And I'll, let you know which of these are true or false as we go through. Generally, when I do this presentation in a live presentation, we have the ability to raise hands, and I don't think we put that into this PowerPoint to be able to do that here. Oh, you did do that. You do have the ability to do that. Okay, why don't we say if you are able to, I don't know how to do this on here. Okay. Oh, here we go. So at the top of your screen, there's a little person that if you scroll and look at the panel, that you can click to say whether you agree or disagree. So if you think any of these are true or false, if you agree, if you think it's true, just say agree, and if you think it's false, then you click disagree. Okay, so the first question, the spouse of a U.S. citizen may not be deported. If you think that that is true, click agree. And if you do not think it's true, push disagree. And I'm just looking at your, so a spouse of a U.S. citizen may or may not be deported. If you think it's true that they may not be deported, push true. So I'm looking at this group of all of you. so we're going to go. So the answer to that one is that the spouse of a U.S. citizen may be deported. So the answer to that is false. The reason is that anybody who is not a U.S. citizen, it's possible that they can be deported. And so assuming that the spouse of a U.S. citizen is not also a U.S. citizen, they may be deported. Okay, next question. The parent of a U.S. citizen may not be deported. True or false? If you think that's true, click true or agree, and if you think it's false, click you disagree. Okay. I think folks have caught that one since I gave the answer earlier. If that's correct, that the answer is false. The parent of a USC sometimes may be deported if they are not a U.S. citizen. Okay, next question. A permanent resident, or an LPR, may not be deported. True or false? If you think that is true, click that you agree, and if you think that is false, click that you disagree. Okay. Yeah, I think I've got a little bit more of an even split on this one. Actually, a legal permanent resident may be deported. Again, if they're not a U.S. citizen, it's possible that they may be deported, and I will talk about that more. Okay. Next question. A person born outside the U.S. may be a U.S. citizen. Is that true or false? If you think that's true, click on agree. If you think that's false, click disagree. Person outside the United States, born outside the U.S., may be a U.S. citizen. Okay. Okay. Yep, I think most of the folks responding are agreeing that yes, a person born outside the United States may be a U.S. citizen. Okay, next question. A person may qualify for legal status based on being a crime victim. True or false? If you think that is true, click agree. If you don't, click disagree. Person may qualify for legal status based on being a crime victim. True or false? Okay. Yep. Getting lots of folks agreeing with this one. I think, yes, the answer is true. A person may qualify for legal status based on being a crime victim. No. However, there's lots of other eligibility factors, and we'll be talking about that when we get to discussing T and U visas. And then the last question, a person falsely claiming U.S. citizenship may be permanently barred from gaining legal status. Is that true or false? So somebody who, for example, checked that they're U.S. citizen the last time they entered the United States, can they be permanently barred from gaining legal status? True or false? Okay, I think most folks know the answer to that. A person generally, somebody who falsely claims to be a United States citizen may be permanently barred from gaining legal status. There is a ground of inadmissibility called the false claim to U.S. citizenship, and that's not waivable. And so we will talk about that and other grounds of inadmissibility when we get to that part of the presentation. So I'm going to move on to specific immigration relief and protections for folks. Just so that you know, I know that most of you do, but I want to give you a reminder. The following presentation is an overview. It's really important for individuals to get specific advice about their own situation, because everybody has different factors in their lives that may or may not make it, so the general rules that I'm going to talk about apply to them. So these are the big red flags for folks. I always, the answer to everything is always like, they need to talk to a lawyer. They need to talk to a lawyer, and we know there's not enough lawyers to go around, but in these particular situations, the answer, they might be eligible for some kind of protection that we talk about today, but even if they are, based on what I talk about today, if they've ever had any prior contact with immigration authorities, whether it's being detained or they've applied for something in the past and that it was denied or whatever, if they've ever been deported or removed in the past, or they have any kind of criminal history, they really need to talk to an individual, an immigration attorney. And when I say criminal history, I'm talking about very minor things as well, especially, people think, oh, I had this old traffic-related incident a while ago, and it may or may not have been a big deal because, a traffic-related thing might have been a DUI, or it may have been reckless driving, or it may have been nothing, important like a speeding ticket. But without exploring some of that, people don't always know whether or not they need to be concerned about immigration enforcement. Generally, for the most part, speeding wouldn't, trigger some kind of removal issue, but we want to make sure that folks actually know that that is what they have in their record, as opposed to some kind of criminal violation. So we're going to talk now about how to get a green card. Isn't that a lovely picture? So this is what the current card as of right now is supposed to be looking like. And my understanding is they're going to be changing that again. I know there have been various versions over the years. Some people have a white card that has a lot less holographs than this one. And in the future, we understand they're changing it again. So we'll see. So the main avenues that most people obtain permanent residence or LPR status is through these particular paths. And they're the ones that are written in the law in 8 U.S. code that allow people to get permanent residence. The majority of folks who have a green card or get LPR status in this country are through a family member. That's about almost 2/3 of the immigration to this country is through a family member. And then the rest of the categories, that other third, are through employment, where the employer sponsors them, or they are coming to work because they have unique qualifications, or through asylum or refugee status, which I'm going to talk about how you qualify for that. And then maybe a 3% or so are other categories that aren't spelled out, some humanitarian ways that are specific to certain kinds of victims. There's the diversity program, which is essentially a lottery program. But the main point about getting a green card or getting LPR status is there has to be legislation authorizing it. And so I always, when I do trainings, I talk about how, some of the rhetoric out there is just go get in line. People shouldn't be able to, cut the line to be able to get status. And the reality is there's no line for, the 11 million people that are undocumented in the country, and that is the challenge that we face right now is there's essentially no line. And the general challenge that we have, is that because there has not been any significant legislation passed in, I want to say, almost 20 years that really looks at the larger structure of the immigration system. There are many, many people in the country that don't have authorization. And so, in the last administration, there was the DACA program created, and the prior administration had tried to create also a deferred action program for parents of U.S. citizens and permanent residents. And, because that was just executive action, there was not, there really wasn't a path for people. The reality is some of those folks in the long run may be able to apply for status, but until we are able to do some major changes to our immigration system, it's going to continue to be this way. So I'm going to talk about the main paths that people get status, about 2/3 of them into this country. Those are either through immediate relatives or through, preference family categories. And I'll go into more detail about this. There's some more slides in the future that kind of lay out what that looks like. But not all family members can bring all of their family members. And so as an immigration lawyer in doing screening with individuals, we try to find out, do you have any family members in the United States who have lawful status? And if they do, what is their status and what is your relationship to them? And so on the flip side of that, one of the privileges of being a U.S. citizen in this country is that you can bring more of your family members than others. And so there's the immediate family member category, and those include U.S. citizens can bring their spouses, they can bring their parents if the U.S. citizen is over age 21. They can bring their children who are without any weight if that child is not married and they're under 21. And then they can also bring their what's called a son or daughter. I've got this reversed in terms of trying to describe this on the slide. So U.S. citizens can bring their spouses, their parents, their children, and depending on the category, it depends, the weight will differ depending on whether that child is married or unmarried and over 21 or under 21. So there are also what are called waitlist categories. Permanent residents can bring their spouses and children, and then U.S. citizens can bring adult children over 21. They can bring their married children, and they can bring their siblings. And what it's meant by waitlist categories is that there's a certain limited number of visas worldwide, and for each country each year. And once all of the visas are taken in those from those countries, the processing stops, and then you go to the next year in order to be able to process more visas. And so I need to move on to the next slide. Okay, so the process is that the individual would file a family-based application or petition, which is known as the I-130. And then, if they're not an immediate relative, let's say it's the spouse of a permanent resident, they have to wait until there's a visa available. And once the visa is available or current, then they can apply to obtain a permanent resident card, or they can apply for a visa to enter the country. And so on the next slide, it gives you a sense of what the challenges are in that if you look at the categories, there is a long wait for visas to become available. So I just want you to look at this slide and look at the little table. If you look at, the definitions of the categories are right there on the top of the slide. But for example, F2A, spouses and children of permanent residents, which is, for each country there's a certain number, and about 3/4 of them go towards that F2A category. So let's say you're from the Philippines, and you're a permanent resident, you want to bring your wife or your husband in, and that would fit into the F2A category. Right now, there are visas available for people who applied in August of 2015, and if you applied after August of 2015, well, if you applied before that, there should be a visa available so you can apply to get your green card at this point. But if you applied, 6 months ago, you are going to wait at least, another 2 years before the visa is going to become available for your country, for that category of person. And so depending on where you fall, look at the dates. F1 means unmarried sons and daughters of U.S. citizens. And so they are processing cases from April of 2006 if you're from the Philippines, or if you're from China, they're processing cases from December of 2010. And so what this means is, and then look at the dates for siblings of U.S. citizens. If you're from the Philippines and your U.S. citizen brother or sister applied for you, back in 1993, you might be able to get a visa to be able to come in right now. And so at this point, this gives you a sense of the line for getting status in the United States. Some of these folks who are here that have family members may have been waiting for years and years and years in order to be able to get their legal status. And so just remember, these are the family preference categories now, and they don't fall into the immediate relative category. And immediate relatives, like I said earlier, they don't have to wait for a visa. They just have to wait for however long it takes for USCIS to process the application. So like the spouse of a U.S. citizen, who, if a U.S. citizen applies for their spouse, it might take 6 months for USCIS to process the case, and then there should be, the person would be eligible to either come on a visa or apply for their green card by adjusting status. And I will talk about adjusting status in a minute if they're in the United States. But there are people, for example, that are in that F2 category who are permanent residents, and they apply for their spouse. People ask me whether there's a benefit for them to, become a U.S. citizen. And one of the advantages if they become a U.S. citizen is that more of their family members may be able to get status more quickly. So I've got a question of, there's a question about if the child is 21 at the time of application, is under 21 at the time of application, I'm assuming, but doesn't get a visa until the child is over 21, what happens? What happens is the child shifts into a different preference category, and so it makes it so they're going to have to wait longer. So that's one of the things that's often a challenge, that that folks age out before the case was processed. And then I have a question. There's a question on here as to why, oh, I missed it. I don't know where it went. Is there a way to see other countries for the weight on the visa chart? All of the other countries fit into the first category, which says all chargeability areas except those that are listed. The ones that are listed are countries where there tends to be higher levels of immigration, but if the country's not listed, it falls into the category on the left. Let's see here. And visas for Mexico take longer than most countries because there's a higher, there's a limited number of visas for every country each year. And the reason it takes longer is because there's been a higher level of immigration from that country in prior years.
I guess all it took was just that one little setting.
Okay.
I know, it's crazy, right? I would have never been able to do that. I would have been like, oh my God,
Okay, somebody on the phone.
Thank you so much for your patience. I was on.
Well, if it happens again, just call it.
Okay,
How to mute that. But anyway,
thank you.
is everybody hearing this?
No.
Okay, yes, you are hearing the background noise. How do we mute that? Okay, so in terms of this particular sample visa bulletin, I mean, if you want to track this, as they move, this is on the U.S. State Department website every month. It changes every month. And so if you just Google Visa Bulletin U.S. State Department, you can get the most current one that comes up every month. But this is the one right now for June of 2017 that I've posted the table on here. And if you're working with individuals that are trying to figure out how long it's going to be, they are posted, yes, monthly, and folks can figure out. Sometimes, when cases run, what happens is new visas are allocated every October 1st at the beginning of every federal fiscal year. And then once visas are all gone, then the cases don't move at all for several months. And so we're getting to that time of year in June where many of the countries have, allocated all of the visas, and the numbers won't move for several months. They might move maybe in a few weeks or something like that, but they won't move for a while until October again. So that's just the reality of how the family visa system works and the preference categories, and why, the reality is if you've got 10-year wait to be joining your, your parent, are we really, how often are people going to wait that long to be reunified with a family member? I'm going to move on from the family visa system to, the next way that people get LPR status, which is through employment. And, I don't know that many of us will see folks in this category, but there are some. I mean, I know our programs work with folks whose, perhaps their spouses came in through an employment-based visa. So in terms of, LPR status through employment, for the most part, it is employers have to submit an application, sponsor employees. For the most part, it's generally only available to those with advanced degrees or certain professionals. And then the employers generally, except in cases where you've got, folks that are really extraordinary, most visa categories require an employer to, obtain a labor certification. In other words, they have to show to the Department of Labor that there's no qualified U.S. workers able to do that job. And so, from what we have seen, many individuals that are undocumented in the U.S. and that don't have family ties are generally not going to be able to get green cards through employment, though, we don't know. I mean, there are a lot of folks right now, I think that, especially those that have DACA or, deferred action of childhood arrivals who are getting, degrees in higher ed. And so we may be seeing, that may be a route for many folks as, they are getting those advanced degrees as we move forward in the future. So I don't, I do want to flag this area of immigration for folks in the event they may have an employer who wants to sponsor them, or if they have some extraordinary ability to be able to apply through employment. The next category is asylum or refugee status, and so there's another 13% of folks who get LPR status through this, and so this is this concept of asylum or refugee status is a one that's recognized in international law. We, as the United States, at least for now, are parties to several treaties that protect folks from persecution or torture or harm in their countries. And so this concept of a refugee, we are a party, at least as of this moment, to the international treaties relating to refugees. And so we are obligated to provide protection to refugees who come to our, who enter our country. And so refugees are those who have been deemed refugees or decided, that they are refugees outside the country, and asylees are those who have arrived at our border or in our country and apply for protection within the United States. And so in order to apply for asylum in the United States, they have to have, they have to apply within a year of entry. There are some exceptions to that. And once they've been granted, once the person's obtained either asylum or refugee status and they've been in the United States for over a year, they can apply for LPR status or apply for a green card. So what refugees and asylees have to show is that they have a well-founded fear of persecution in their home country, and that persecution is based on that person's race, religion, nationality, political opinion, or membership in a particular social group. So those in refugee camps are, have been adjudicated or decided by the Commission on Refugees, the International Refugee Agency, that yes, this group of folks are eligible for protection under the Refugee Convention, and they have a well-founded fear of persecution in their home country on one of these bases. One of the challenges of the work that we do in this arena, especially right now for the folks that are arriving, this is an area where it's very, very difficult for people to apply for these protections without legal help, because one of the things they have to do is show how they fit into one of these categories, and that what they have experienced rises to the level of persecution, number one, and number two, that they were actually persecuted because of race, religion, nationality, political opinion, or membership in a particular social group. And I want to just flag for you that, what we do know right now is, so the federal government can, they set a cap of refugees, how many they're going to take every year, and right now there's, the previous administration had agreed that they were going to take, I believe, 120,000 refugees this year, and then the new administration came in and they lowered that number to about 50,000. I have a question about, what are the contours of a particular social group, and I'm going to talk about that when we get to victim-specific protections. So I will address that when we move on. But this concept of refugee or asylum status is, general violence in the country, a war going on, general strife is not enough. That person has to show individualized, persecution, and then economics, of course, is not enough. There have been cases in the past that show, people can show where they were particularly targeted in an economic way, that they might be able to apply for status, but generally poor economic conditions in the country is not enough. So I'm going to talk now specifically about immigration-related protections for victims of abuse, different kinds of abuse. This handout that is here, did they get it all as a separate? You should have gotten this as a separate PDF in the materials, or you can get that. But this is a graphic that's been designed by DHS, the Department of Homeland Security, for their own training. And so this is just trying to get all of the various victim-related protections on one page that has a general description of what the eligibility factors are. It's not comprehensive, but it is, it's a nice graphic that can be helpful in trying to summarize all of it. It's as good of a graphic as we've been able to find in terms of just articulating all the various categories that people who've been victimized might be eligible for. So I'm going to talk about the Violence Against Women Act and the particular protections that are afforded under that. And, you know, one of the reasons I spent all that time talking about how people get status generally is that I wanted to help frame where these various protections for victims in particular fall. And so the original Violence Against Act self-petition protections are based on the family-based preference system. So back in 1994, when the self-petition was created, it was based to, it was created to address this problem where, a spouse applied for their wife, and because, part of the application for a spousal-based petition is that you have to show good faith marriage. You didn't enter into this marriage for the purposes of getting an immigration, to get immigration papers. And so people would be staying in abusive relationships because they were concerned about, their immigration status. And, the self-petition process was created in order to take away that power imbalance around the abuser being able to say, if you, you tell anybody that I'm abusing you, I'm going to turn you over to immigration, I'm going to have you deported. It was intended to remove the, immigration tactics or the, control tactics based on immigration status from the dynamic. And so the VAWA self-petition was created, so for spouses and children of U.S. Citizens or permanent residents who are abusive, there is now this a way for the non-citizen to be able to apply for their own status. And so that was the original protection that was created, and in later versions of VAWA we added parents of abusive U.S. citizens. And so in the self-petition context, if they have that requisite family relationship with a permanent resident or a U.S. citizen, so it's based on the family preference system, if they could already have immigrated through a U.S. citizen or permanent resident sponsor, then they can apply for a VAWA self-petition. And if that petition is approved, they can get a green card. And so this is, just to remember, the self-petition process is based on the family visa preference system. So, if they're married to a U.S. citizen, there's not a wait for a visa. If they're married to a permanent resident, they're going to be in that preference system, so they may have to wait 2 years for a visa to become available. And in the meantime, while they're waiting for the visa to become available, they can apply for deferred action, which I mentioned earlier is this category where the government recognizes that you're here, you're undocumented, but, we'll prioritize you for removal. So the VAWA self-petition is based on that framework. So the next category, we created this in VAWA 2000 because we recognized that not everybody was married to a U.S. citizen or a permanent resident. And initially, the advocates that worked on this, we wanted it to parallel the VAWA self-petition process, and we wanted it to be a self-petition process as well that, crime victims could apply, they could attest that they were victimized, and they could self-petition as well. Well, that did happen. Congress did not accept that. They didn't move forward with that proposal, and so they created this other thing. And it's called the U visa, crime victim visa. And so what the U visa is, it creates a non-immigrant visa for victims of certain crimes, including domestic violence and sexual assault. There's actually a long list of other crimes, including human trafficking or kidnapping or forced fraud in foreign labor contracting or stalking. I mean, I don't have the list on here. But is it on here on this other thing? We'll have to get that list. But the person has to have suffered substantial physical or mental abuse, And they have to have been helpful or willing to be helpful in the investigation or prosecution of a crime, and it has to have occurred in the U.S. or violated U.S. law. So there doesn't have to be a relationship, any kind of family relationship or marriage with the perpetrator, though certainly somebody who's married to, an abuser who's undocumented would be eligible if they are willing to be helpful in the investigation or prosecution of the crime. And this is the next couple things are the biggest challenges with the U visa process. The application must include a certification from a law enforcement officer or a prosecutor or judge or government agency that is responsible for enforcing the criminal statute, investigating or prosecuting certain criminal activity. They have to certify that this person has been helpful in the investigation or prosecution of the crime. Now, there doesn't have to be a prosecution that moves forward. So technically, somebody who's called law enforcement and given a report, that should be sufficient. Some law enforcement agencies won't sign a certification if somebody doesn't continue to be helpful. But generally, the law enforcement agency has a lot of discretion as to whether or not they're willing to sign these certifications or not. And this has been one of the big challenges in terms of advocacy around the country has been, law enforcement agencies or prosecutors, et cetera, may not even know what this is. They're not required to know what it is, a U visa certification. And then others, agencies may set up, varying standards on when they're willing to provide such a certification. So that has to be included in the application. And then the other parts that people have to show is they have to, document how they've suffered as a result of the crime, that they may have, physically been injured or they've, suffered mental anguish, et cetera, and provide that documentation. So some people, may be getting, hospital records, doctor's records, counseling records, et cetera, or, submitting an application, a declaration explaining how they've been harmed. And so, there's those pieces that they have to do. The other challenge with the U visa process is that there are only 10,000 visas available annually for this process, and what we have been trying to do for the last 10 years is trying to lift the number of visas available because there's a 10,000 visa cap. And what this means is, the visa was contemplated to be for victims of domestic and sexual violence originally, to be for those folks who weren't eligible for VAWA because they might not have been married to their abuser or they may have, had an abuser that was undocumented or whatever. But so originally when the U visa was created in 2000, there was no concept of that this program would be so well utilized. But given the reality of the fact that there are 11 million people out there that are undocumented, and any certain percentage of them will have been affected by violent crime in a given year. I mean, if we look at any statistics about criminal, victimization of the general public overall, if you were to just take that percentage and apply it to the undocumented population, it's going to be, hundreds of thousands of people. And so many of those folks have applied for U visas, and we certainly don't want people not to do that, but the reality is we've not been able to lift the numbers for this U visa or pass any kind of comprehensive immigration reform, and so the program is completely oversubscribed. And right now there are about 150,000 people in that wait list. And what we know is, given that there are that many people in the wait list right now, what we're hearing is it's taking them, 3 years to adjudicate that first application to begin with. And so right now they're just adjudicating cases from the summer of 2014 And we know that the weight, given there's 10,000 visas a year, is going to be a minimum of 7 to 8 year weight, at a minimum. I mean, it was growing more and more every year as more and more people apply. And so that is our challenge right now. I mean, certainly we recommend if people are eligible and they can get a law enforcement certification that they should go ahead and apply because, that may offer a little bit more protection than being undocumented overall. But just know that is, the biggest challenge of that program right now is that it's oversubscribed and the lines are not waiting any faster. And so, I talked about folks who might be eligible for some other status. For example, if they're married to somebody who has legal status, for example, a permanent resident or a U.S. citizen, and that person is the abuser, they're going to have a much faster path to go down the VAWA self-petition route. And so we sometimes people don't realize that they're actually eligible for some other kind of protection that's going to be a lot faster. Okay, I'm going to move on from the U visa, and we can talk about some of the practical implications as we go along. Okay, the next one is asylum or withholding or removal. So I mentioned this earlier, that people who have to show that they fear being persecuted in their home country because of race, religion, nationality, political opinion, or membership in a particular social group. In the context of the work that we do with domestic violence and sexual assault survivors, generally we are going to be using those last two prongs, whether it's political opinion or membership in a particular social group, as the basis for asylum or withholding. And this is the part that people really need legal advice on, that we highly recommend that they work with an experienced immigration attorney, because how that particular how that claim is formulated or articulated to USCIS will determine whether or not the person is going to, be able to win their claim. And so, for example, you may have a victim of domestic violence here in this country who, has suffered extreme domestic violence in their home country. And they get to the United States and they have to articulate why they believe they've been persecuted in their home country. And the law does recognize, for example, if law enforcement in that person's home country is unable to stop the harm that is happening to that person, that may, you can show the persecution through that lens, but then you also have to show what group you fall into. And so, over the years, we've, there have been cases that have, talked about, well, you can't just say all women generally, because all women in the country are not, targeted in the same way. You couldn't say, oh, women who are of, in this particular region, because, then you would have to prove that everybody, all the women in that particular group are targeted in the same way. So it gets to really being able to finesse, I know some people have been able to articulate, women in a particular family, with this, name are targeted in this way, and law enforcement was unwilling to do anything about it. And so there is, different case law that, develop some of the parameters around that. But, everybody's situation is going to be different. And so people really do need legal counsel to be able to help them sort out how you frame, the group that they fall into and how they are have been targeted or persecuted. So there's that piece. The other piece is in order to qualify for asylum, meaning if the person's here in the country and they're applying for this protection, they have to show that they apply within 1 year of arrival. Otherwise, they're not eligible for asylum, and unless they can show some exception as to why they didn't apply in that first year. For example, they could show, perhaps they had some other lawful status, so they didn't need to apply, or they were hospitalized, or they were traumatized, injured, and so they couldn't apply because they physically couldn't do it, or maybe in the case of young people, children, they weren't legally required to, able to do that because they were a minor and didn't have the legal capacity to do it. But they have to, generally, the rule is they have to apply within 1 year of arrival. Otherwise, if they were put into removal proceedings, they could apply for a defense to deportation, which is where there's a higher legal standard, meaning they're eligible for withholding of removal, but they have to show it's more likely than not that they would be persecuted if they were deported. And then in some cases, there might be a protection under an international treaty relating to protection against torture. If they were likely to be tortured, if they were returned to their country, they can apply for that defense to deportation. So, but what these defenses to deportation are is they don't grant LPR status in the end. They are just defenses to deportation. And so it means that those folks, they can't be removed to their home country, but they are not actually eligible for LPR status in the long run. And so for those folks that are not eligible for asylum, maybe because of the 1 year filing rule or because they might have some other criminal reasons where they are ineligible for asylum, and I'm going to talk about some of those in a minute, but they can, they can seek protection from deportation under these, general categories, international law that says you can't deport somebody to a place where they're going to be persecuted or tortured. Okay, so there's that. The next category of protections for some victims are, and these ones are for those under age 21, for youth. There's special immigrant juvenile status. And this is in cases where youth have been abused or neglected. And it can be just one parent. So in cases where you've got, perhaps you're working with a kid or a young person who is here with their mom who is, not abusive, but perhaps they were abused by their other parent. If you're able to get a state court order that says, that youth is dependent on the court or, can legally commit that child to, the state's custody or, under some kind of guardianship, and there's a court finding that that youth cannot be reunified with either one or both of their parents because of abuse, neglect, or abandonment. And the court has to make the finding that it's not in their best interest, the youth's best interest, to return to his or her home country. And the youth is generally under 21 and unmarried. In some states, because of how their dependency system works, it's limited to under 18. But in any event, if you can get that kind of state court order, folks can apply for special immigrant juvenile status, and that is done in an affirmative application, and there are various groups that are helping young people with that. And so just don't forget that if you've got, a client in front of you that's under age 21, that might be a route to explore. Okay, so there's a few other protections that are available, and I'm not going to talk a lot about that, but there are victims of human trafficking. The T visa is available, and generally that also involves, this is actually a lot of people that apply for the U visa may be eligible for a T visa, so it's worth exploring if they've been a victim of exploitation, and they're here because of under forced fraud or coercion, or they're engaged in sex trafficking, or they've been not engaged, but they have been forced to engage in a sex or labor because through forced fraud or coercion, they may be eligible for a trafficking visa. And there is not a 7 to 10 year wait for that right now. There is a 5,000 visa cap for T visas, but that has never been fully utilized. And so just to flag that for folks. I'm not going to talk a lot about TPS, but there are certainly a lot of folks right now that from these countries that are listed on the slide that currently have TPS, including a few Asian countries. And so, be aware that you may have folks that you're working with that may either be eligible because they've been here that long, or they may have their status expiring sometime soon, and so maybe exploring other protections for you, or for them. So anyways, just if you've got folks from these countries right now that are wondering whether or not they're going to have status in the next year or so, you'll want to be checking in with the news about whether TPS still exists for them and when the decisions are going to be made to provide that, whether there's going to be the status is going to expire sometime soon or not. Okay, and so the next large group of folks is, I'm not going to spend a lot of time about this. This is not victim specific, but we have many people in this country, and this is what's getting all the news right now, is deferred action for childhood arrivals. The original program was created in 2012 to defer deportation for all of these undocumented young people who had to have arrived in the United States before age 16 and have lived here since June of 2007, and born after 1981. There are a lot of people who may be eligible for deferred action but never applied, and my understanding is in the API community there are a lot fewer people than applied who are eligible. I mean, there are certainly a lot of undocumented young people from our communities who never applied, and they may not know that they were eligible, or they may have made the calculated decision to not apply because they didn't want to turn all their information over to immigration, because now immigration has all of that information. So what we know about it is that it's completely up to the administration as to whether they're going to, what they're going to do. And we keep hearing rumors about possible executive orders or not, but it's over 750,000 people right now that have applied for DACA, as of September of 2016. And we, there are proposals for bills to be introduced to extend that status. There are various proposals that have been floated in the news about ending the program, so we really do not have any idea what's going to happen. But lots of folks are organizing, of course, and I'm sure many of you in your communities are as well, organizing to try to make sure that this group of young people continue to have status. Okay, so employment authorization. This is not necessarily a legal status per se, but you have to have some kind of status in order to obtain employment authorization. And so green card holders or LPRs do not need a work authorization card. Their green card is enough. Their legal status allows them to work for any employer, generally in the United States, and they can't apply for president, of course. And there are some categories of employment, especially in government, that don't allow green card holders to apply. But generally, there's no time limit on when, how long green card holders can keep a job or work in a job. And then there are certain temporary statuses, that come with a work authorization card that people have to apply for and that are valid for, maybe 1 year, maybe 2 years, maybe 3 years, and people have to apply for that and renew it. Sometimes folks can get an employment authorization document while the application is pending, and in the past that has been true of cases such as people applying for asylum, or applying for a trafficking visa, or applying for some kinds of other, for adjustment of status if they're waiting for a green card. And in the past, the programs allowing for that have been much more generous and flexible and timely. And it's not just this administration, but over the last several years, a lot of categories have gotten much more difficult to get applications done in a timely way while applications are pending. And so, for example, we know that the administration right now has been talking about doing much more thorough vetting of applications. And so, they are not interested in letting people apply for work authorization in a lot of categories where they have in the past, while they're still waiting for the application to be approved. And so we are seeing that in the context of U visa cases. For crime victim cases, right now it's taking 3 years for that initial application to be decided even, and then people are put into what's called deferred action, and that will probably take, another 6 to 7 years at least, if not more, depending on the number of visas available. And so right now what we're looking at is people, waiting 3 years to even get their first work authorization. And so, some of the advocacy we're doing is to try to allow for employment authorization while the application is pending, and we are going to continue to advocate for that, but not that optimistic at this moment in time on that. And just know that at the national level that many of us are working on that. In any event, if folks have a work employment authorization document, they can get a Social Security number and work. And, if folks don't have legal status, there's no application pending, then they are not going to have employment authorization. Okay, so the employment authorization generally is what people want, to be able to do, is they want to be able to work lawfully. And the long-term route to be able to do that is obtaining permanent residency or green card. So this concept of obtaining the green card or permanent residency is, I described earlier, people get their status through family or through employment or through humanitarian refugee status or whatever, or even a temporary U visa for 3 years. What happens is, so the initial application is approved, and USCIS makes that determination. The person's eligible because their spouse sponsored them, or the person's eligible because their parent or their employer sponsored them. So USCIS makes that initial determination. Are you eligible to fit in this category? What happens next is then, in order to apply for permanent residence, is then they may need to look at the individual applicant and decide, okay, even if you're eligible, is there anything that disqualifies you from being, able to get that permanent residence? And so assuming there's a visa available, a visa number available, they can apply to adjust status. They can either, if they're outside the country, they come in on an immigrant visa and they're processed at the consulate. But if they are not in the, or if they are in the U.S. already, then they would be required to apply for adjustment of status. And what you need to know is, in order to apply for adjustment of status, they have to be eligible to apply for adjustment of status. Not everybody who's in the United States is eligible to apply to adjust status. And this has, been the big challenge of a lot of people who, even though they have a family member that sponsored them and they might have a visa available, they're not actually eligible to adjust status in the United States. They have to leave the country and process at their native consulate. And so, that can have a lot of implications. Number one, separate from the cost of it, it may mean that folks have a very long wait outside of the country, and they're going to be separated from their spouse while they're waiting for that consulate to process the application. And, my understanding of, some consulates, it's going to be a couple-year process because of just the sheer number of applications that they're processing. So, as a general rule, those who cross the border without inspection, they cannot adjust status via, their family member or through their employment, except there used to be this provision in the law that existed prior to, if the case was filed before April of 2001, if you paid this big $1,000 fine, you were allowed to adjust status in the United States without leaving. But that expired in 2001. And so now everybody who has an application that went in after that date, if they entered without inspection or permission, they are going to have to leave the United States to process the case. There are some exceptions to that. We have created in VAWA some exceptions, in the VAWA self-petition context. Those folks can adjust status within the United States. And generally, if somebody entered on a visa, they may also adjust status in the United States. So, if they're not eligible to adjust status, they have to leave, like I said earlier, to process through the consulate and obtain a visa. But, here's the map of the, if you look at just the screen or the flow chart, they may have to leave the United States. So if you look at the blue box, are they eligible to petition? Yes. Let's assume they are. Was there a wait? Let's assume that the wait is finished and they've waited their 3 years, their 5 years, whatever. If they're in the United States, are they eligible to adjust status? Yes, if they are, they can do their interview here and then they can get a green card. But if they're not eligible to for status, they have, if they're in the U.S. and they are eligible to adjust status, are there any bars to them being able to get that green card? And so I'm going to talk about those in a minute, but generally some of the categories include, criminal-based grounds, et cetera. Or if they're outside the U.S., they process on the consulate. And again, the consulate's going to look at, are there any bars to them getting a visa? And are they able to come in and on the visa and get their permanent residency? So I'm going to talk about what some of those bars are to people adjusting status or getting a visa to come in. So, in looking at an individual person, we want to know whether the ground of inadmissibility applies to them, do the facts of this person's situation, establish each of those elements of that ground of inadmissibility. Is there an exception to that ground of inadmissibility for them? I mean, we've been very successful through VAWA in creating different grounds of, exceptions or waivers that people can apply for some of the grounds of inadmissibility. So, keep that in mind. Some people might be eligible for more than one form of immigration relief, and they decide to go one route because there might be a waiver or an exception. And, an immigration lawyer is going to want to explore all of that with folks. But the biggest basis that we see most commonly, a ground of inadmissibility, is that person is present without admission or parole. And so, certain immigration violations make somebody inadmissible. And so in the current context that we are in right now, just to put this in a larger framework, the previous administration had laid out its priorities for removal, and those priorities included, folks with certain serious criminal grounds. This administration has laid out in its enforcement priorities essentially, folks with criminal grounds, various immigration violations, including these ones. And so as I talk about these various grounds of inadmissibility, just know that they are now listed in the priorities for immigration enforcement and in the new administration's interior enforcement memos. And I'm going to talk about that tomorrow for those of you who are interested in signing up for the webinar that we do tomorrow. I'm going to be spending some time really talking about the executive orders and what they are saying are immigration priorities for enforcement. But just know that these are included in those lists. And so those who are present without admission or parole is one category. Those who've committed misrepresentation, including false claim to citizenship, they would make somebody ineligible to adjust status. Know that I've highlighted on the slides there are some exceptions and waivers for people that apply for status under VAWA. So those who have self-petitioned may be eligible for some kinds of waivers or exceptions. So, if people are eligible for those, that is a route that they can go that a lawyer would want to explore with them. Other ones, these are ones that immigration is going to know more about, so it may make people even more of a target for removal. But if they've been deported in the past, they've been removed in the past, they're going to be ineligible they're inadmissible, and there's no, specific VAWA waiver for that, prior ground of removability, or excuse me, that ground of inadmissibility for a prior removal. So just know that if somebody's inadmissible for this ground, they may not even know that they have this. For example, if somebody was ordered deported in a deportation case that they didn't appear for, like they didn't even know they had a prior deportation order because they didn't get notice of their case, and they didn't go to their court hearing, and so they might have a prior removal order. Another ground of inadmissibility is unlawful presence, just being in the country in violation of a visa, for example. There are some exceptions related to VAWA for that one, as well as unlawful presence or having had a prior removal order and having a subsequent lawful reentry. So I want to flag the process related to these. That second inadmissibility ground on this slide, unlawful presence. It's a ground of inadmissibility, and it only kicks in after a person leaves the country. So if the person is for example, the time in the U.S. they had on their visa expired, and they left the U.S., if they were in the country for over 6 months without authorization, and they leave the country, it triggers a 3-year bar to their reentry. And then if they were here a year without authorization and they leave the country, they are subject to a 10-year bar to reentry. And then this last ground, if they were here with unlawful presence for a year, they were deported before and they left and they entered again without inspection, an unlawful reentry, they're subject to a permanent bar. So they're not going to be eligible to get a visa or apply to adjust status. And so the important thing to remember, there are waivers in the context of the unlawful presence bars, and then there is a VAWA specific, only a VAWA waiver. Actually, so for the unlawful presence bar, the 3 and the 10-year bars, there are some general waivers that are available for, spouses and children and relatives of U.S. citizens and permanent residents. And then there's a VAWA exception to that, so it doesn't apply to VAWA cases at all. So, if people are wondering which kind of case to pursue, VAWA is a much more beneficial type of immigration case. Now, the one where there's unlawful presence and then the person was, or they were deported and they left and then they re-entered again without inspection, there's the permanent bar, and the only exception to that, or the only waiver to that, is through the Violence Against Women Act, and that person has to show that they have been, there was some kind of connection between the abuse and the unlawful reentry or whatever. And so this is the conundrum facing a lot of the cases that you're reading about in the news is, there's folks that have come in and out and in and out, and they might be married to a U.S. citizen now, and they have an application that they've put in that's been approved, but they're inadmissible, and they have a permanent bar to their being able to get status. And so that is some of the very highly publicized cases that we're hearing about right now where, you don't understand why, they are barred forever to get status. It's because they are faced with, this permanent bar, or they're faced with, because they, had time in the country and they were unauthorized, they left and they came back again without inspection, or they've been ordered deported in the past and they came back again, to be reunified, for example, to be with their children, and they are not eligible for any kind of exception or waiver to that bar of inadmissibility. On the next set of bars of inadmissibility, I'm not going to read them all. They're, generally criminal grounds. And these are the specific, terms that are used in the law. But, I'm not going to, go through each and every one of them, though, there are some waivers that are available for some of the grounds, but there are not waivers for, all the waivers, need to show, the person needs to show that a U.S. citizen or a permanent resident, spouse or parent or child would suffer exceptional or, some kind of extreme hardship if the person wasn't admitted. And so, criminal grounds are the big red flag, and folks really need to go get individual advice about how to deal with them. I mean, what we are seeing now is that folks that have prior criminal histories, folks are looking at, if they have these things in their past, they may be looking at trying to reopen old criminal convictions or applying for, various, post-conviction related protection in the state or, family court that, or excuse me, state court that is not specific to immigration, but, that will often be the only path for some folks that have some prior criminal history to be able to regularize their status. Okay. And then just, as the people that have been able to get a green card finally, that in the end they may be able to naturalize if they've been in the country as a permanent resident for over 5 years, or if they're married to a U.S. citizen after 3 years. They have to show meet other requirements like general knowledge about U.S. history and government, and or be able to speak English or read English relatively adequately, etc. And the big red flag again is that if people have criminal convictions, that USCIS or ICE wasn't paying attention to, they may bring that to the attention of ICE, and so folks should be, if they have any kind of criminal convictions, they need to be talking to a lawyer about whether it's even a good idea to apply for citizenship. certainly people are end up in deportation proceedings by having been permanent residents for sometimes even decades. And so folks need to go back in their history all the way back to when they first got their green card. It could be 20 years, it could be 5 years, it could be 30 years. I mean, convictions can be super, super old and still be now grounds for removability. So, you know, it's okay. We don't need to. I'll move on from that. So I just want to talk about, you know, so if your clients or folks you're working with do end up in removal proceedings, and as I mentioned, you know, there are a lot more people that are being deported these days. I mean, we have seen, unfortunately, in the news, a 40% increase of people being removed that are, that are, don't have any kind of criminal history at all. And so what I want to talk with you about is, you know, what that means and how, you know, what to do about it. You know, we went through some of these concepts. If, you know, the person is detained, we should figure out, you know, we need to figure out, you know, ICE is going to figure out whether they should be deported from the U.S. They're going to want to know if there's a ground in the law to deport them, and if there is, whether there's some kind of defense to deportation. People who are deportable include those that don't have any status, current status, and it includes people that have been permanent residents or that have visas that, you know, and may have had them for a long time, but they might have some criminal conviction. I do want to flag for you that some people don't even get removal or deportation proceedings. They never get a chance to present a case before an immigration judge. And these involve folks who are put into expedited removal. And generally that's somebody who can't show that they've been in the U.S. for 2 years or longer. Generally within the border confines, but the new immigration executive orders say that expedited removal can apply to, you know, folks even in the interior. They're starting to talk about, you know, creating expedited removal, engaging in expedited removal of people in the interior of the United States as well as just along the borders. Or if they've been deported before, that previous deportation order can be reinstated. And so to be aware, that's why folks want to, you know, certainly get advice if they've ever been deported before, because they might not get a chance to present any new evidence or information or a defense if they, if immigration just decides they're going to reinstate their old order. And often, you know, how people end up in removal, I mean, the most common way now is, you know, interaction with the criminal legal system. ICE detains people after they've been in jail or in contact with a probation officer. I mean, this is what the current dialogue is about in the political arena, about whether local jurisdictions have an obligation to hold people beyond their criminal sentences. And, you know, the vernacular around that is, you know, a community that refuses to hold people beyond the term of their sentence are called, you know, being called sanctuary cities or sanctuary jurisdictions, though, you know, that term is used differently and different people use that term in different ways. But the conversation at the national level is really about this concept of whether or not local jurisdictions are holding people they have in their custody for ICE in the context of ICE detainers. Other people end up in removal proceedings because, you know, a case was denied. That's what happens in asylum cases. If the application isn't looked at favorably, then that person has a chance to raise their asylum application in deportation proceedings. And then, other interactions with ICE and Border Patrol, whether at checkpoints or in this current administration, we are definitely seeing it as collateral to other enforcement activities. ICE going out to go pick up somebody that they're actually affirmatively searching for because of an old deportation order or a criminal conviction. And then somebody else happens to answer the door or is there. And so, we are seeing much more of that. I do also want to flag for folks, in the past, people in removal proceedings may have been detained or not detained, and the prior administration, would look at whether people had, family members that depended on them, dependent children, U.S. citizen relatives, et cetera, to decide whether or not they were going to detain them or not. The default now is for more detention, notwithstanding the fact that people may have family members, U.S. citizens, or permanent resident family members, or young children, et cetera. And so the default is definitely, yes, folks should be detained. And so, if people are detained until they have, their immigration court hearings, and we know that people don't have a right to appoint an attorney in immigration court if they can't afford a private attorney. I mean, people do have the right to an attorney if they have one, and but there's no right to a free or an appointed attorney. So most people are forced to represent themselves. And I, in the past have practiced immigration in Washington State, and I know in my jurisdiction over 92% of the folks in immigration court are not represented. And so, for those of you, I don't know, how strong of relationships that you have with your local legal services providers, so that, or, if your folks end up being detained and then shipped to another facility across the country, which is not all that uncommon these days, there is a network of nonprofit legal services providers at this website that's providing for you in the slides. And then there's also private immigration attorneys through the American Immigration Lawyers Association. This is their website information. And I just want to flag for you for deportation cases. There are not a ton of private immigration attorneys that do pro bono deportation defense work unless, they're looking at class action litigation and they're trying to, government in some way. And so, there's not a lot of free legal resources, but there is more and more, the nonprofit providers are trying to do much more training of pro bono attorneys, under their supervision. And so one of the realities of the current state of affairs, there are a lot of attorneys that want to do, are trying to volunteer to do more of this work. And so our hope is that they are linked up with experienced removal defense attorneys who are helping provide supervision and guidance, because it's not an easy area of law. So I'm going to move on. So the reality is, people are detained. It either ends up in people being deported, ordered deported, or sometimes they're granted what's called voluntary departure. And that sometimes leads to the very best thing that happens is they have to leave the country, but they're ordered, they get a grant, what's called an offer, a grant of voluntary departure. And what that means is if they leave, there's not a deportation in their record in history, which may mean that, they might be able to apply for protections or, some kind of immigration relief in the future. They may be released on bond and to be able to, work on applying for some kind of relief in the future. They may be granted parole depending on the individual officers in that particular situation. Or they may be granted some kind of status. All of the various statuses I talked about earlier, people can apply, say they're applying for them, even though they have some kind of detention or deportation case happening. And so what can happen is ICE can either decide to close the deportation case, or people can actually apply for some of these forms of protection in front of the immigration judge. So I'm going to talk about, for those folks who are not detained yet, but are, if they were detained, might, become deportable, or, might end up deported. And the reality is that until we pass some kind of, comprehensive form of immigration relief or protections for people, the, majority of those 11 million people here without status are not going to be able to apply for some relief. And so, what can undocumented people do, and what can we do to help them? I'm going to talk about this as, I'm going to spend a little bit of time on this first topic right now, and then some of these other pieces I'm going to talk about tomorrow in the presentation on safety planning. But certainly we want people to keep informed of developments, and so, the media is certainly doing a lot more reporting about that these days in the news, and we will send up periodic changes and updates in terms of wide-scale, developments in the law. Certainly make sure people are aware of scams. This is a huge problem right now. So, checking in with credible websites and resources, and we have provided a bunch of those links at the end so that you all can track what really is happening, so that if people are making promises about getting some kind of status, that people are aware that there are a lot of scammers out there. Making sure that, folks are consulting with an attorney or accredited representative, saving money in case folks are removed or, need to pay an attorney, and then collecting and saving documents that show that folks have been residing in the United States, especially if they've been here for over 2 years. They want to be doing that because we don't want folks, being removed without any kind of chance for a hearing at all. So, we have a few minutes left, and, the next several slides are just basic know your rights. And I encourage you as advocates to really go through these with folks, to practice them. I mean, it's really important to practice them, because I don't know how many people we hear about that, accidentally let ICE in, they agreed to something, they end up being deported because they were too, they gave up too much information that ICE could use in deportation proceedings. So if agents show up at their people's doors to find out if they're police or ICE, to ask. Certainly we are hearing about ICE officers wearing police uniforms across the country. They can do that. I know that a lot of local law enforcement agencies are very unhappy that ICE is doing that, because the level of fear that that's striking in the community is making it so people are afraid to call the police, of course. So it's really important that folks know not to open the door until they can figure that out. For example, to ask that, that information be shown either through a window, through a peephole, or, that if there's paperwork to be shown, to be slipped under the door, whatever. If ICE agents don't have a warrant signed by a judge, they cannot enter a home without permission from an adult. So again, like I said, ask to see the warrant, have them slip it under the door. If it's not signed by a judge, you don't have to let them in. So I want to flag this for you. A warrant that is signed by an ICE officer. It's going to be on a form I-200 or an I-205. Essentially what that is, it's like there's an officer in the ICE office that's like a supervisor, and they, are okaying that their ICE officer can go out and pick up this person. That is not enough to enter somebody's home. Your home is, in this country, we have what's called the castle doctrine. It's this long-standing concept that the government cannot enter your home unless they have probable cause and that a judge has decided that to be true. And you have the, generally it plays out in different ways. You have the right to defend your home, and we won't go into all of that. But so an ICE warrant is not enough. It has to be signed by a district court judge, so U.S. District Court. And, if they're asking for a household member and that person's not home, you ask them to leave contact information. You don't have to tell them where that person is, and you shouldn't lie. But if, just making sure that if they don't have that warrant, they don't get to open the door and come in. Now, the problem is, of course, that's what the law says, and you don't have to affirmatively let them in. We do know, and we have certainly heard of instances where ICE, they either come in because somebody let them in, or they enter forcefully. And so if they are in your home or at your program, for example, you have, it'd be good for them. My recommendation these days is, given how much that we are seeing on social media, or folks have cameras on their phones these days, that, is maybe helpful to be documenting what's happening in these interactions. So let them know their children or other vulnerable residents at home, or asking politely that they exit, step aside unless they have a warrant. I would, like I said, recommend that people practice, I don't consent to you being in my home, please leave. Talking through this, if they begin searching, to affirmatively state, especially if you can document this somehow, I don't consent to your search. If ICE is arresting you or detaining you, letting them know you have medical issues or need to arrange for your children if that's actually true. And so being as, in a very intimidating, and I know it's so easy for me to say because I'm not facing this right now, and we wouldn't necessarily be either, but certainly I know some of you advocates have had ICE at programs or have had to deal with this, and so just being, I highly suggest role-playing, practicing, all of those things to be able to, do that in a really scary situation and figuring out how to document all of what's happening. We say this in the event it's not going to necessarily stop them from detaining people, arresting them, physically dragging them out. But to the extent that any of it's documented, if they violate the Constitution or violate the law in carrying out their duties, that may be a way to have, cases thrown out or the basis of, some kind of action against them in the future for having acted outside the boundaries of what the law allows. Okay, now assuming that folks are detained, if they are detained, they have the right to not answer any questions, to not, they have the right, like in a criminal case, the rights against self-incrimination. ICE officers, immigration officers are really good at figuring out how to, get information out of you. So not sharing where you were born, your immigration status or criminal history, asking to speak to an attorney, et cetera, and not signing anything. Having a plan in place for if your family is detained, and we're going to talk about that more tomorrow in our presentation tomorrow. And I've just provided an ICE locator website so that folks can try to find folks if they are detained. And this is just, go to the ILRC's website. Folks have been effective or successful in just showing this to an ICE officer, and your agency might have something similar, that instead of just answering any questions, they just give this to the officer and say, I'm not answering any questions, you have to speak to my attorney, and then making sure that folks have, their attorney or some kind of contact information for somebody to talk to them, or I'm just not going to talk to you until I talk to an attorney. And, we're going to talk about this much more tomorrow in our presentation on safety planning and advanced safety planning. But I've provided several resources for you on where you can get general information, whether about, the overlap with gender-based violence or specifically about immigration. Some of these immigration concepts, are applied to survivors. I mean, they're going to apply to survivors generally. And then some more specific safety planning related resources under additional resources. So there we are. We're at 2 hours, and I'm happy to try and take a few more questions if there are, or if we've got safety planning specific questions, we can. I'll be covering those tomorrow in our webinar tomorrow afternoon. So I am happy to try to respond to any questions in the chat at this point. Okay. Okay. Sure.
This is Shirley, also from the Institute. I just wanted to give you a quick note about the materials for the webinar. Everybody should have already received the slides that were just presented. If you haven't, you can go ahead and contact info, I-N-F-O, at API-GBV.org, and I'll send them out to you. The webinar will be recorded and shared on our website, as well as the slides and other information and materials on immigration.
Okay, I'm getting, so some of the specific question about a student, somebody married to a student on a student visa, they potentially could apply for a U visa if they, reported to law enforcement, and law enforcement's willing to certify that they've been helpful in the investigation or prosecution of, for example, an assault or certain criminal activity. So it's potentially somebody who is on a student visa could do that, yes. Somebody who's received a green card, yes, can travel outside of the United States. And so, yes, if you've obtained a green card, yes, you should be able to go leave the country and re-enter. Just be aware that, there's all sorts of, news about returning and eventually you'll be able to enter, just that the process of vetting people re-entering or at the consulates is more time-consuming, much more than in the past, perhaps. Let's see here. Does being married to a U.S. citizen in the military expedite the citizen process? It's supposed to. There's supposed to be a faster way to do that, though my understanding is, I've been reading about that lately, that I don't know if the office that does those cases is very well staffed right now. There's a little bit of flux around some. I was reading about this very topic on immigration lawyers listserv the other day. So it's supposed to, and so certainly try to utilize that process, but it's a function of staffing. Question: if a child's been in the States for about a month and his mom, 5 years old, with cerebral palsy, I'm not sure what that is about. In terms of, if a person needs to get medical care, the question is whether you are, so they're not going to be eligible for immigration status based on their health. Nobody's going to be eligible for, if they don't fit into one of those categories I listed, such as family-based, employment-based, humanitarian, like asylum, crime victim, etc., They may be able to stay in the United States for longer than their visas allow if they apply for what's called parole, where if the government decides for humanitarian reasons, they might be able to do that. But no, there's not any kind of legal status based on somebody needing medical care. And one of the concerns may be that, that folks are going to have to show that they're intending to return to their home country at the end of all of that. So, but there are some processes called, for humanitarian parole, some kind of that, folks may be able to apply for, extended period of time to get medical care. Let's see here, what else? Well, the question is, though, if this involves a crime that was committed in the United States, the mom may be able to apply for a U visa, or they may be able to apply for asylum. If they've been subjected to violence in their home country and the government was unable to protect them from that, they may be able to apply. But that would really involve some in-depth, interviews with immigration lawyers to explore that. So, yeah. So what I would recommend in some of these very specific cases, think through the categories that I've explained and see if there might be some argument that somebody fits in one of those categories. But it's really going to involve an individualized analysis with, going through all the person's circumstances, not just, and I would highly recommend to not put any more in a public chat, please. It's really, folks really should get individual confidential advice. Let's see here. Yes. Okay. No. Yeah. Okay. Yeah. Okay. So yes, use the links in the materials. I highly recommend developing relationships with the nonprofit legal services provider in your local community, and develop as advocates those relationships so that you can turn to those immigration attorneys that are there in your community and work with folks. So, okay. I hope that many of you will join me tomorrow on the safety planning chat. We're going to talk more specifically about what the executive orders that came out in February are, and talk more about what it means to do safety planning with victims of domestic violence and gender-based violence, and what kind of systems we need to be working with in order to better help survivors figure out how to navigate through those systems. So, thank you.
All right, thank you everyone for joining. We're going to close out now. Please feel free to download the materials or access the evaluation in the web links box. Everyone will be directed to the evaluation after the close of the webinar. And please feel free to email us if you have any questions about registering for tomorrow's event. Thank you so much.